Hello everyone, welcome to the series of public international law lectures by the Global Institute of Law. My name is Paras Zafar, currently a research fellow at the GIL. In this lecture, we will be talking about a very crucial topic, that is, International Criminal Court and the human rights. Today, we will explore the relationship of the human rights on the one hand and International Criminal Court on the other. Thus, we will cover following three main topics. Number 1, an introduction to the human rights, its brief historical background, and key human rights legal instrument. Secondly, we will be looking at a brief introduction, structure, and the mandate of the ICC. And finally, an in-depth discussion on the significance of ICC in upholding, preserving, and protecting the human rights. And thus, we will be able to know that what is the significance or what is the relevance of the ICC in the human rights. Starting with the introduction. So before going on to describe what human rights actually are, it is of paramount importance to know the meaning of the phrase legal rights. The term legal rights, in the words of Sir John Austin, refers to an interest that is recognized and protected by the law. Human rights are therefore defined as those fundamental freedoms and interests to which a person is entitled merely because of being human. Because human rights are only available to humans, so therefore here arises a question that who is recognized as a human being in the eyes of law. This question has now already been answered by an eminent jurist, Sir John Solomon, in the following words. As the human beings are those who are capable of having interest as well as capable of having duties and punishments imposed on them. Thus, the phrase human rights is a comprehensive word that refers to all those rights to which all individuals are entitled to by virtue of being human, regardless of their color, race, religion, gender, or any other difference whatsoever. Thus, we can say that these are the rights which are recognized to be inherent and integral with the human beings, about which there cannot be any dispute and there cannot be any question. So, moving ahead with the historical background. Whenever anyone talks about the history of the human rights, it will not be wrong to say that human rights are as old as the human history itself. Because the origin of the human rights can be traced back to the last sermon of the Holy Prophet, peace be upon him, that was delivered on the 9th day of Zulhaj, whereby he had emphasized on all kinds of rights for all the persons, including women's right and a person's right to life and property. A later milestone in the history of human rights was the Charter of Liberties, that is also known as the Magna Carta 1215. The Magna Carta 1215 was basically an agreement between the England's King John and rebel barons, and through this document, the governing power of the king was prevented from being arbitrarily used against their subject through the instrument of due process of law. Throughout the British, the Magna Carta is celebrated as a sign of the freedom and liberty from the oppression of the then king. The Magna Carta was written in the Latin and it consisted of 63 clauses, and it established certain rights for the very first time in the European history, such as a right to own property. Moreover, the writ of habeas corpus was also established, according to which no one was to be imprisoned without lawful authority. Moving ahead to another important document in the evolution of human rights, it was in 1689 that the King of England was forced to agree to the British Bill of Rights as a condition to occupy the throne. The British Bill of Rights was also a step forward towards the recognition of the human rights. Moving ahead in the history, and another evolution in the regime of individual human rights was the Bill of Rights, that when it was introduced into the US Constitution through an amendment in 1789. Furthermore, in 1878, such rights were made inviolable by way of 14th Amendment to the United States Constitution, and this era is basically known as the constitutionalism of the human rights, as it was for the very first time that certain rights had been incorporated into the Constitution. and moving to the key legal instruments which are very important in the recognition of the human rights. And here we will be talking about the stage of internationalization of the human rights, because this was the time when the human rights were recognized throughout the world. So first of all, the main important documents in the history, or we can say that in the internationalization of the human rights, first of all, Charter of United Nations. Secondly, Universal Declaration of Human Rights. Thirdly, ICCPR and International Covenant on Economic, Social and Cultural Rights. So, before moving on to further and before describing each of these instruments in detail, a question here arises that whether these human rights have been created by the instruments or treaties. The answer to this question is no, because human rights are not created or developed by these treaties or instruments, but these treaties, or we can say that the covenants, have only recognized the rights and merely codified them. So, first of all, when looking at the Charter of the United Nations, Charter of the United Nations was the very first document that incorporated human rights at an international level. Because United Nations had two main objectives. First of all, its primary objective was to maintain peace and stability among the member states, while its secondary objective is to protect the human rights. So basically, for the purpose of protection and promotion of the human rights, United Nations General Assembly, in its third session on 10th of December 1948, adopted a historical document that is known as the Universal Declaration of Human Rights, or UDHR. Fortunately, UDHR was adopted by a majority of the states at that time, with the exception of few states which denied its adoption on the basis of certain religious and racial grounds. So, today's conception of the human rights is rooted and based upon the UDHR. The importance of the UDHR can be expressed in the words of former UN Secretary General Sir Ban Ki-moon when he stated that, "In a world still reeling from the horrors of the Second World War, this declaration was the very first global statement of what we now take for granted, and that is the inherent dignity and equality of all human beings." Indeed, this was the very first time that the international community consisting of the sovereign nations of the world declared a set of fundamental rights and freedom that each and every human being on this planet is entitled to, regardless of their color, sex, religion, national or any other status, whatever it may be. The rights and freedoms contained in the Declaration range from the most fundamental ones, such as a right to life, liberty, freedom from torture and slavery, and including many other civil and political rights, such as equality before the law and freedom of thought, and key social, economic, and cultural rights as well. Moving to the legal status of the UDHR. So, it must be kept in mind that UDHR is merely a universal declaration regarding human rights. It is neither a treaty nor a covenant, and therefore it lacks the necessary binding force. The Universal Declaration of Human Rights now lacks a binding force, but the rights enshrined in the UDHR have received recognition by being incorporated into two covenants that were adopted by the United Nations General Assembly. The first covenant is International Covenant on Civil and Political Rights, that is called as ICCPR, and it came into force on 23rd of March 1976. While the second one is International Covenant on Economic, Social and Cultural Rights. It came into force on 3rd of January 1976. So, while the UDHR may not have a direct binding force, but still it may be indirectly binding on all the member states who are parties to the covenants. So therefore, it can be said that the UDHR was basically a stepping stone, firstly for the ICCPR, and secondly for the International Covenant on Economic, Social and Cultural Rights. And one may say that together these three documents form the International Bill of Human Rights. Moving ahead, the revolutionary aspect of these instruments was that the states for the very first time voluntarily subscribed to legally binding documents which imposed obligations on them concerning their domestic affairs and the treatment of their own citizens. Now, despite of various treaties and covenants in place for the preservation and protection of the human rights, still unfortunately the global promotion of the human rights continues to be a momentous challenge. Because countless people in the various regions still do not enjoy many of the most basic rights and freedoms enumerated in the Universal Declaration. At this stage, what is particularly alarming is that fundamental human rights, including the right to life and liberty, freedom from torture and inhumane treatment, continue to be frequently and flagrantly violated in many quarters of the world. Moreover, all too often such violations take place in the context of war and armed conflicts, which in themselves represent the ultimate threat to all human values. And it is for these reasons and these flagrant violations of the human rights that it could be said that the ICC is relevant. Now moving firstly to the introduction of the ICC. ICC or International Criminal Court is a permanent court of last resort based in The Hague, Netherlands. ICC prosecutes the most serious crimes of concern to the international community as a whole. It began its functioning on 1st of July 2002, and ICC was basically established by a treaty that is called as the Rome Statute that was negotiated by the United Nations, and it established the court. Moving to the historical development of the ICC. So, whenever anyone talks about the historical development of the ICC, it would not be wrong to say that the idea of an international court that judges international crime was not new. Because Paris Peace Conference of 1919 and League of Nations in 1937 had also suggested for the same. Moreover, in 1990, the General Assembly of the United Nations requested International Law Commission to begin working on a draft for such a court. International Law Commission is basically a group of legal experts that is associated with the United Nations. ILC presented its draft in 1994, and after several committee meetings and significant edits, a conference was held in the Rome in the June of 1998 to vote. Finally, on July 7, Rome Statute was passed, and after July 1st in 2002, when 60 countries have ratified the statute, then ICC was finally established, and therefore the court was allowed to prosecute crimes that occurred on or after this date. Moving to the structure of ICC, so International Criminal Court consists of 4 principal organs. Number 1, Presidency. The presidency of the ICC oversees the court's administration and management works, and it consists of 3 judges who are elected by other judges for a period of 3 years term. Secondly, the Judicial Division. The Judicial Division of ICC consists of 18 judges who serve in the court, and they are appointed for a period of 9 years. And it is also a mandatory requirement that each judge must be from a different country. Thirdly, the third organ of the ICC is Registry. Now, the court's registry is responsible for the non-judicial matters such as translation services or detention units. And finally, the final organ of the ICC is Office of the Prosecutor. Office of the Prosecutor is in charge of the investigations and prosecutions. Prosecutor may open a case that is referred to them by the state party or United Nations Security Council or on its own motion. The prosecutors are also appointed for a period of 9 years term. And here we will be having a discussion that how ICC is significant in upholding and preserving the human rights. As we all know that International Criminal Court is a permanent judicial institution that was set up to end impunity for the most serious crimes of concern to the international community as a whole, namely genocide, crimes against humanity, war crimes, and the crime of aggression. Now, whenever we look closely at the offences which are stipulated in the ICC statute, then we will be able to know that how they relate to the universal human rights norms. First of all, ICC has jurisdiction over the crime of genocide. Article 6 of the Rome Statute enumerates 5 forms of genocide, and genocide itself is a massive violation against an entire group of people by way of killing its members or otherwise bringing about its destruction. Secondly, the statute defines a number of crimes against humanity, and basically Article 7 of the Rome Statute enumerates 15 crimes against humanity, which are offences such as murder, rape, imprisonment, enforced disappearances, deportation, sexual slavery, torture, and many more. Now, it is important to notice that the genocide and the crimes against humanity do not necessarily have to occur within the context of an armed conflict. Thirdly, Article 8 of the Rome Statute contains a long list of the war crimes, and basically 50 forms of the war crimes have been mentioned therein, with a separation between those that are punishable in an international armed conflict and those that constitute crimes in a non-international armed conflict. So, whenever we see that the prohibited acts under the Rome Statute in a large part concern the most fundamental human rights, preemptory norms of international law such as right to life and freedom from torture, but there are also offences which particularly affect women and children and numerous other connections to specific human rights. For example, freedom from racial discrimination and the freedom of movement and fair trial rights. So therefore, it can be stated that the crimes which are made punishable by the Rome Statute and which are triable by the International Criminal Court are those crimes that directly violate fundamental rights, and indirectly they can affect the enjoyment of almost any of the basic human rights or freedoms. Therefore, ICC is significant and it is relevant in the preservation and protection of the human rights. To conclude, it can be said that ICC was devised by the international community as one means of fighting the impunity of the world's gravest crimes, which affect the most vulnerable members of our societies, particularly women and children. The ICC is a neutral, judicial, non-political body which observes the highest standard of the fairness and due process, and it is relevant and it is, although very much significant, protection of the human rights and punishment of those individuals who are liable for the violation of the human rights.